My name is Shelley Binder, and I'm Development Director at the Workers Circle. Thank you for joining us today at our webinar on year-end financial planning. We have people zooming in from all over the US, so please take a second and post from where you're calling into the chat. We'd love to know that. So, at this time of the year, we are encouraged to step back and review our retirement, financial, or legacy plans. Jonathan Gudema is our plan giving expert, and he'll be talking with us about strategies for year-end financial planning and those important check-ins that are recommended. Jonathan is an attorney, senior advisor at PlannedGiving.com, and the principal of Planned Giving Advisors LLC. Jonathan has 30 years of experience working with advising nonprofit organizations on planned gift arrangements and tax-advantaged charitable estate planning options. Prior to founding Planned Giving Advisors in 2011, Jonathan was a managing director at Changing Our World, the third largest US-based fundraising consulting firm. Jonathan has also held senior positions in planned giving at the Anti-Defamation League, United Jewish Communities, and Continuum Health Partners. Jonathan earned a BA in political science from Rutgers University in 1990 and a JD from Western New England College School of Law in 1994. Jonathan's presentation will be around 45 minutes. Please post any questions on the chat, and Jonathan will be happy to respond. Now, please join me in welcoming Jonathan.
Okay, thank you, Shelley. Thank you, Workers Circle. Let me share my screen and we can begin. Okay, all right, so I want to welcome everybody. I think this is the third or fourth year in a row I've given us this similar presentation. So again, I'm happy to be back. I've been doing work for the Workers Circle maybe 5 or 6 years already. So it's my pleasure always to be back and give these presentations. And this one we had, since we're going to schedule this to happen right after the election, so that was also some of the thought process. And so we're going to cover that too in terms of some of the things we need to think about. But again, thank you, Shelley, and again, thank you for having me back. Okay, so getting ready for December 31st. The first topic is, any impact this election may be having on our planning, and then we'll get back into the really important stuff. And as you'll hear from me, I've been an attorney for 30 years. Most of my time, I worked more with nonprofits, and at a certain point, I became a in-house attorney for a family wealth office. But I've always done wills and basic planning with individuals, and more and more the last couple of years, I've gotten much more into that area, and just not even though I've worked on over $1 billion of wealth transfers and pretty much that much in terms of charitable gifts, but I enjoy finding out situations that I can help people through. And so this section is very, very important in terms of just double checking if you have everything in order, some ideas to really help you in this regard. And that's the strategies to consider. And lastly, just talking about your legacy and either charitable legacy or family legacy, and we'll get there soon. Okay, so I was wondering, and I found a statistic, something from Finance Buzz, the presidential election impact on finances, really. And the point of this slide is people are concerned, over 50% in the different categories of Republicans, Democrats, Independents. Basically, everybody is showing either very significant impact. They feel that who is a president or impact or the next latest screen, and or even some impact. So we're seeing overwhelming majority of people feel that the presidential election has has some sort of impact on the finances. And I'm going to cover a couple potential issues that were out there, even regardless of the election, a little bit, and a couple of ideas are out there post-election. But again, I'll mention this. I think I'll mention this, and when I get those bullet points, all these different ideas are thrown out there. These proposals, campaigns, promises, or threats or whatever you want to call them. But when it comes time to actual legislation, usually you don't see any of the more extreme ideas and anyway get implemented for various reasons. So probably even before we get into this topic, there's probably take a deep breath and from a financial perspective, it's not there's nothing extreme coming unless you're a billionaire. You never know with that. Anyway, election impact and on election impact on your planning. So the one issue that's been out there since the 2017 Tax Cut and Job Act, basically implemented in 2018. If you recall, this was the Trump administration's big bill, one of the only bills that got passed. This was a tax cuts, but this was there was a lot of things done in this bill, and just so we remind ourselves, all these tax legislation, anytime any legislation is going to require, is going to reduce revenue in any which way you can, anytime that's going to happen, um, they have to make it up somewhere. So these bills are cut here, but add here, and of course they have to expire. And so we've known this all along, and so we'll go a couple things here. So essentially, the gift estate and gift tax exemption is supposed to expire at the end of 2025. What is that? That is every individual, every single one of us, young and old, we each have a lifetime exemption. It's combined both gift and estate tax, meaning you can give it away. You can give away a certain amount of money. It happens to be over. It's I think $13.6 million per person. It was doubled in the 2017 Tax Cuts Jobs Act. So it would drop down to each individual. If it expired, um, it would go back into that whatever level it was supposed to get to, which was probably around half of the current level. So what this means practically speaking is that um, anybody with a husband and wife double it, but any individual has with around $13 million in assets, cash, stock, whatever value, there's no federal estate tax or gift tax, so you could give it all away right now. You'd have to report it. You'd have to do a gift tax return. You'd have to ask your accountant. I found accountants don't really know how to do gift tax returns. I don't know how complicated it is, but it can get very complicated. But tell you if you're making a gift above I think it's 17 or 18. I can't believe it. The number, there's the annual gift tax exclusion amount. It used to be 10,000 a year. You can't give, if you go more than that, you'd have to report it, but you don't have to pay taxes until you exceed your lifetime giving. Now it's over 13 million per person. So this number dropping in half, had this happen, it wouldn't be a earth-shattering event. Probably what would happen, and it's not going to most likely because obviously due to the election, this will probably be either extended or who knows what they're going to do, but it will not be dropping in half at the end of 2025. But again, there's something we have to be cognizant of. Anybody who sort of fell in the middle and didn't feel like they needed to do estate planning for to avoid that federal estate tax because it didn't apply to them because they had under 13 million assets. Somewhere in between, you might start getting worried. But again, there's nothing to do here, and there'll probably be legislation either extending that same current level or even expanding, or who knows. There was the tax brackets. There were some adjustments to tax brackets. Most people in that bill got a 1% to 2% reduction in their overall taxes, and it would bounce back to whatever those rates were back in pre-2018. Again, not likely to be a problem, or there'll be some sort of adjustments in this regard. Either way, probably within the first year. Standard deduction would drop back in half. Now, one of the positives or negatives, depending on how you look at it, at a 2017 tax bill, was that the standard deduction, which is every individual, when you do your tax return, if you don't have a lot of deductions, you get the standard deduction. It's like $12,000 per person. It's changed over time because I'm trying to think back when we had it. So it used to be like 9,000. I think the last one's up to 12,000 per person. They doubled that exemption. So essentially, the taxpayers who are itemizers. So you only itemize in your tax return if your deductions exceed the standard deduction. But now they bumped it up. They doubled the standard deduction. So essentially, a husband and wife, for example, we'd have to have my wife and I would have to have over 24,000 of deductions to be no longer using a standard deduction. Then we'd be what's called itemizers. And there are 90% of taxpayers, 90% of taxpayers use the standard deduction. So that's why I'm mentioning it here. I see there's a chat here. I'm going to answer the question, but which means only 10% of Americans actually have enough deductions that they'd actually become what's called an itemizer. Again, I don't want this class to be all about these details, but I had to just mention them. Yes, somebody asked a question. It's a great question. I'll read it out loud. What 10,000 SALT limitation? Question mark. I will get to it very shortly. And I will describe what that is. So anyway, again, if this Tax Cuts and Jobs Act had expired, that standard deduction, which got doubled, and that would drop back in half. But then you might get something called personal exemptions. I love personal exemptions. I have a lot of children. Personal exemptions I think $4,000, another similar to the standard deduction. You also get this $4,000 per person in your household. So I have 5 children. You start doing the math. It was a very nice deduction for me. We lost that back in that bill. So that was, we gained something maybe in the standard deduction doubling, but we lost personal exemptions. Maybe they're going to come back again. Probably not, but possibility. And that wasn't the question. Thank you so much for asking the question. SALT stands for state and local tax, and that was one of the things that still irks people like me. Since then, this was ironic. If you live in a higher real estate tax area, let's say I live in New Jersey, my real estate taxes exceed $10,000 per year. Not that I live in such a big house, but they do. And so my deduction for my real estate and state taxes has got capped at $10,000 in that act, and that's something that I think both parties have mentioned fixing or just giving it back to people. So this is hard because one of the nice things in homeownership is you get a deduction for the real estate taxes, but now it's limited to 10,000. So let's say I had my real estate taxes about 13,000, and my state income taxes another $10,000 or $20,000, whatever that is. I can only deduct 10,000 on my federal term. I believe that even though the first Trump term actually was the one who put this in place, I recall that they have said that they're going to fix this or undo this, because this was a little bit negative on people who live in higher tax brackets. It's a little unfair, and that higher tax neighborhoods. So if you're in New York or New Jersey, California, not so pleasant for us. If you live in a place where your real estate taxes are much lower, wasn't such a big deal. But in my neighborhood, there are people paying 30 or 40,000 a year in real estate taxes. So again, all that used to be deductible, now it's not. There's going to be some adjustment there. So that is good news. There was an adjustment on mortgage interest deduction. Now the mortgage, they started limiting it on that law, so they're gonna but it only applied. Limitations only apply to the jumbo loans. I think it was $600,000 loans or higher. There at a certain point you start losing the deductions on the mortgage interest. I haven't heard anything about that coming back or not, but because it was such large loans, I didn't feel it has such wide impact. But of course, if it impacts you, it doesn't matter whether a lot of people get impacted. It's not great for you. Obviously, if it reverted and you want that deduction back, that'd be great. But the child tax credit. I think the child tax credit, which is for any you get basically like cash being paid on your behalf. A tax credit, if you don't know this already, is essentially saying you paid $1,000 in taxes, and it can get the money literally will pay your taxes that you owe, or you'll get it back in a refund. So this child tax credit was doubled in that act. That would drop back down to 1,000 again if it expired. But again, I think both parties did not intend for that to happen. It only applies for children 16 and younger. So your kids, as they grow up, they may have already aged out of it. My youngest, I have only one under 16, so for me personally, it wouldn't be such a big deal. But I currently get the $2,000 child tax credit for my 11-year-old, and I got a couple of years left. Please God for that. Okay, so that was just some of the couple issues out there, things that would expire. We're not sure what was going to happen again. Either way, Congress really needs to act on this. Just a couple ideas have been thrown around. I don't even like to even say. I don't want to call even proposals. Just a couple ideas. Candidates throwing ideas around doesn't mean very much, but clearly they've said they want to fix the SALT, the state and local tax issue, either reinstate what it used to be or adjust it. I would be very happy to see that happen, and I think that will happen. Oh, very nice idea. Elimination of tax on Social Security benefits. That would be great for seniors. I think that would be a nice boost. But just remember, we always have to remember, nice ideas. It's a reduction in revenue, and if if the federal government's going to take less revenue, they're going to have to find it somewhere else. So again, that always gets me worried. It's not a partisan issue. It's more of a like practical issue. I've studied these big tax bills for 25 years. And the results are kind of weird. If you really look at the details of tax bills, you get some really strange things thrown in there. Well, we're reducing this revenue or this tax, but then they're doing something else that causes you to pay more on a different tax. So nice idea to reduce the taxes on Social Security benefits. Not sure they can swing it and particularly because the country's gotten pretty old. Within 5 years, over 20% of the United States will be age 65 or plus. And then to reduce tax on all the income that they have to make up that income from someplace, which again, it's got to come from somewhere. So the tax bills have got to be revenue neutral, which means they can't, if you're going to reduce revenue and taxes, you got to, in one part of the bill, you got to increase it in another. And that's where you get really strange results. The idea, of course, keep the current standard deduction, which is again $12,000 per person. Again, give or take, there might be some adjustments that I don't remember. So basically $24,000 for a husband and wife, and keep that child tax credit pretty high. Nice idea. Again, floated by exempting overtime pay and tips. The tips was floated by two candidates. That's all I want to say. Both of them said, "Oh, we don't want to tax tips." I'm laughing like, do they even tax tips? This is cash, but okay. So that would be nice. Overtime pay. I'm in favor of it. It'd be nice if they did that. Excluding income for firefighters, police, military, federal and veterans from federal tax. Again, nice idea. Got to pay for it somehow. So again, there's no not likely. You just can't. The way these things work is you cannot. You cannot. You got to have. It's got the bill. Whatever bills come up, they got to be revenue neutral. And then we spend, after the bills come out, we spend, like myself, attorneys and tax professionals spend weeks reading these things. I usually just read summaries from law firms that they give me because there are thousands of pages. I would never get through it. So not likely to happen, but it's been thrown out there. Okay, so all right, so just interesting point. I want to talk a little bit now about really important ideas. Again, I meet with a lot of people. I do free consultations for a lot of individuals. Just have questions about wills and trusts and basic planning. I found a statistic here from caring.com. Okay, percentage of people in each generation who have a trust, will, or estate plan. And we're going to talk about these basics, important stuff. Silent generation, it's only 54%. I thought it'd be higher than that, but this is what they're saying. Boomers, 57.5%. Again, I would have thought the boomers are getting older. Sorry, boomers. I'm not a baby boomer. I was born right after the baby boom. Only 50. If it's shocking that it's not a higher number. Now, the Generation X, that's my generation, a little less. That okay. We don't have any money anyway. Millennials obviously are younger. Again, that doesn't surprise me. That's actually pretty positive. They're younger, yet they got into their estate planning, so I expect more. Gen Z, a little less. Fine. So why don't people have wills? Just one last statistical page, and we'll talk about some real practical steps. All right, so there is data out there that suggests that only 32% of Americans have a will in place. Again, obviously, as people get older, the percentage goes higher. But we just saw that the silent generation, the baby boomers, not more than 60% of them, in the 50% range, have wills and trusts and things in place. Why haven't people done it? Well, some of they just haven't got around to it, and which is a very common thing. Even someone in their 80s may have. I had somebody once tell me, I was talking to a woman. I had to follow up with her on something she said to us in one of our materials, and I knew she was in her 80s. It just popped up when I looked up her number, and she told me yes, she's thinking about including this organization in their estate plans. She just hadn't gotten around to it yet. I'm thinking, like, I know how old you are. You're in your 80s, but I had to be, I didn't say anything. But so it is common. People don't want to rush to this some often, or they don't feel at 33%. They don't feel they have enough assets to leave to somebody. But I tell everybody, anything left in your name that needs that you have to change title of it. It could be a car, could be real estate for sure, or brokerage accounts, things like that. You need a will to tell how it's going to be distributed, or okay, you can rely upon what the state has to say. The state will distribute these assets under the state laws, what's called state intestacy laws. Those laws are laws when you don't have a will, but that may not be exactly what you would like. And I'm not going to go into those details, but you could guess that they're not always what most people would want. Some people think it's too expensive. Nowadays, honestly speaking, there are online options. There are some free options, and you can get this done at a pretty good rate. I do recommend having an attorney. So the do-it-yourself options are a little problematic. Most of those programs or online options, I would guess to say, is that the legal documents themselves are probably completely kosher, fine, legally valid. But there's a lot of little things that the document itself is important, but you've got to execute it properly. You've got to handle it properly. So you should spend a little money. You should get an attorney involved at a minimum. Well, they don't know how to create one. Well, you could always call an attorney. It's not that complex, but okay, that's how people are thinking. Okay, so again, I started off talking about, I last year in particular, I've had a lot of meetings with individuals. I hear a lot of stories. I've been working on a lot more individual plans with people that in their wills and power of attorneys. They need a living trust or a irrevocable trust. Again, we'll talk about this. So let's talk about the will, the last will and testament. I want you to look at your will closely. Find it, take it out. Now, if it's in a safety deposit box, it probably should not be there unless you're a child or your chosen executor has access to that account. Because again, just remember, if you are the only one on your safety deposit box, if you pass away, if you don't have another person on the box, they have to get a court order to get into the box. And so you don't want, the will is not something you want to have to get a court order to go get it out of the safety deposit box. So please take it out, take a look at it. Is there anything missing, any signatures, anything unusual? I had a client of mine, we were doing some elder planning, which I actually talked about some of what we did with this woman, and she said, what about the will? And I've got it. I don't even remember, she showed it to me. It's a long time ago. But then 10 years go by. The client, she did pass away, and I was helping her daughter, and we pulled out the will, and it actually had the signatures, but the quality was not good. And either it wasn't the original that we had, or the original was so old that the court didn't think it was an original. They said, well, this is a photocopy. We couldn't prove it either way. So the will was rejected. They had to do a different thing. The daughter had to get appointed as the administrator of the estate, but it created big hassles for my client. The biggest question: does the will reflect your current wishes? Quite often people write these wills and they don't look at them. Well, you've got to see, as the executors, has there been anything changed? Have you moved state? If you change states, you really need a new will, because the state you were living in is where you create your probate. Now, you could have to create a probate if you own real estate, for example, in Florida. This is just common. I've had to deal with this before. So, and you live in New Jersey, that's my state. I'm a New York and New Jersey attorney. So how do you deal with the real estate in Florida? So you have to open up the estate, the executor. Hopefully there's a will. Hopefully the will gets admitted to probate in New Jersey. But then you're going to have to open up a second probate in the state where you own the real estate. Actually, as we're going to get to a little later, that's a good reason to have what's called a revocable living trust, so that the trust doesn't have to go through probate. They don't have to create a whole new probate process and add another state. So that's a reason for doing the revocable living trust, but we're going to get there in a minute. But have you moved states? Definitely, you have to have a new will. Have you changed your executor or the beneficiaries? It's all very important issues. Yeah, and the other thing I'm going to mention more than once in this presentation, you've got to ensure that it can be accessed by access to those who need to get it, need access to your will. Because again, one of my suggestions to when I sit down with people and we finish a will, finish a bunch of different documents, a power of attorney, I said, okay, now where are you going to put this? Now, sometimes they know me, they're in my neighborhood. They say, listen, we want you to hold on to it. I said, okay, but most of the time, I'm not a regular law firm, so I don't suggest that. Law firms are much more organized, and in any case, I suggest a special folder, maybe a fireproof folder. Not that you're worried about fire, but again, it's something that's different, and we know exactly where it is, and we're going to tell our executor and our family members where these documents are, and so it can be found. And obviously, you want the person who's going to be the one who's going to literally take that will and go to the probate court to get it submitted to probate, or go to an attorney who will take it and go get it admitted to probate. You want that person to have access to your will, the one to have it. Now, I'm saying that because let's say you have a niece or nephew or other relative has access to them, and they're next in line, and they come in, they find, you gave out, you split it up a certain ways. They don't like it, or they can either just literally rip up the will and go what's called, just have ignore the will, or they can, if sometimes they find old wills. Here's a piece of advice I always tell everybody: ready? Your old wills, you need to destroy them. You cross them out, you void, tear it up, burn it, whatever you want. But if that is no longer your wishes, you don't want to be a fallback, you got to destroy it. Now, if you say to yourself, well, I want it to be around just in case the first one fails, they will turn to the next will. Okay, but you better really trust those people who are the ones who have access to it. Again, there's no way to police this. And so I definitely suspect this in many cases where particularly if people have been holding on to old wills, and beneficiaries come in, don't like the more recent wills, they can just literally throw them away. The hand is raised. Let me okay, hold on one second here. Is there any questions? Wait, hold on a second. I just want to make sure no questions. If you want to ask a question, put it in the chat feature. I think that's the best way. I'm not sure I'll see anything else. So if there's any questions, please do a chat. I will see that. Okay, and you may need to create a new will. I know it's hard for people. It is a cost. I myself have tried very hard to make sure that this is very affordable way for people to do it. If you have friends with attorneys, usually they do these as almost favors. So I talk to an attorney and say, listen, I know you may not be your specialty, but do you do wills? You probably need a new one after any of these issues that I've mentioned. Is there what's called a self-proving affidavit with a notary? That's sort of a second document that goes with the will. Again, if you're missing that, if you have a regular will and you signed it and two witnesses signed it, but you don't have another page with you signing and the two witnesses and a notary signing again the will, then they'll have to search for those witnesses. That's a problem. And if you can't find those witnesses, the will will not get admitted to probate. So, and again, they'll ignore it or they'll move on to an older will. Okay, so power of attorney. really, really important document. I only in the last couple of years have I come to that conclusion. Because power of attorney is a document which you empower a spouse, child, or close friend, somebody you trust implicitly. Now, trust this person really because you're basically writing on that you're giving them powers to transact financial transactions for you and other things. They can literally go to your bank and remove all your money. They can really sell real estate if you give them that power. Very, very important. So you got to look at that power of attorney closely. Now, there are two types of power of attorneys out there, but there's only one I recommend. Hold on, I see a question. I see a question here. There's a question in a raised hand. I don't know if you should acknowledge it. Okay, so I'm not sure. I'm not sure about this question. Again, if somebody put a question, please put the question in the chat because I'm not seeing the other Q&A. Okay, so let's look at. But once I see the question, I'll answer it. Power of attorney, very important document. So if you become disabled, you can't make decisions for yourself. That you need somebody to be able to help you manage your finances, who can literally write checks on your behalf, sell things, whatever, help manage property. It has to be somebody you trust. There's a one type of power of attorney, a general power of attorney, is or called a durable power of attorney. That from the moment you finish that document and you hand that and the original should go to the person who you're appointing that power of attorney. They literally can go ahead that moment from forward, then go ahead and remove all them, throw all the money out of your bank account, or whatever it is, whatever they want to do. Obviously, you have to trust that person, but you need somebody with this power. Now, there is another type of power of power of attorney, another type of POA. Another type of POA is called a springing power of attorney. Now that most people say, oh yeah, I want that. If I end up in a hospital under certain conditions, then the power of attorney kicks in. The problem with those, and I won't draft them for anybody, is that you cannot, then you're going to need to have a court hearing for the court to determine, bringing in medical experts that you've met whatever standard you put into that document. So we lawyers in general, myself included, do not want to do those types of power of attorney because it's going to create headaches much later on. If somebody needs to use it on your behalf, chances are they will not be able to use it without a court hearing, and that defeats the purpose because usually this is in times of emergency. So we want to look at that closely. We want to any signatures missing? There's power. I found this over and over again. People show me, a client of mine, it's a continuum care community. So people move in there in their mid 50s or older, stay for the remainder of their lives, usually. And I review all the documents for anybody there. And almost every time there's a list of powers you can give or not give to your power of attorney. And sometimes people want to give them all. Sometimes you want to choose. You're supposed to initial each spot, or you can initial one spot which covers all the spots. But anyway, these are usually messed up, and I always have to look at it. And every time I look at it, I find mistakes in all the power of attorneys I see. Power of attorneys, you look at it, it's just it's a form document, but again, not a bad idea. If you're talking to an attorney, have them do the power of attorney for you, and make sure it's ironclad and it'll work when you need it. Because when it happens, you can't use it. It's a really big problem for people. To reflect your current wishes, is that person the right power of attorney? Have you moved states? Again, I had somebody move from New Jersey to New York. New York, the bank's car lease company would not accept an out-of-state power of attorney. I was shocked, but if you move states, you're doing a new will, you should do a new power of attorney also. And you really need who you choose to have your power of attorney, your POA, is that person should have the original. Again, just important. Create a new power of attorney if needed. Again, it goes along with a will. Most lawyers should include a package. They'll do a will and they'll do a power of attorney also. All right, beneficiary designations. This is my number 3 major area. Maybe even more important than the first, because most people have the majority of for average people, typical people with not more than a couple $1 million of assets, retirement accounts, things like that, is where the bulk of their investments are. And I just beg people, please look at those accounts and those policies carefully. Policy, I mean life insurance policies or investment accounts, but mainly or IRAs. If you have beneficiary designations on these accounts, which is a good thing, because the funds will not be guided, will not be covered by your probate. Probate's where the will is admitted to probate, and that process is to change title of anything that needs to be title changed. But if you have a beneficiary designation in any accounts, it just bypasses, it goes right to them. You say, well, that's good. That is actually very good, but not good if your estate is imbalanced. And you've got to have, if you want to leave your children equal amounts of money, let's say if 3 children each get a third, but then you have a large retirement account, which has only one of them as the beneficiary, you either better trust that child to distribute the assets the way you wanted them, or that's it. I had a client, well, a bunch of children, and we did a nice will, we did the power of attorney, and he said, oh yeah, he's got something in his retirement account. But then when he passed away, the majority of his assets, his anything he had of value was in the retirement account, and it was only left to one daughter, not the rest of the daughters. And the family dispute after that was horrific. So kind of look at these things. You got to sort of have a big picture and how's it getting distributed. Make sure if you want to, I love beneficiary designations, very important. You want to make sure it's been submitted properly, it's recorded. You can go online these days and it should be able to figure it out. If not, call and ask the company, you want to confirm who your current beneficiaries are and how it's being divided up. And did you change your mind? And is this the estate division you intend? So again, these are just very, very important. I call these potentially lopsided or unintended results could happen if you haven't looked at the big picture and realizing how much you're giving away through beneficiary designations. And again, you need to update them as needed. Other really, really, really important steps. I goes hand in hand with what I was just talking about, an inventory of assets, holdings, locations, information, accounts, passwords, account numbers, anything you can. It should be in one place. If you feel comfortable with an Excel spreadsheet or a Word document, something, or you can get a handwritten, just handwrite it up, but somewhere we know everything is, because again, we want people to get access to these things, and things do get lost. There's billions upon billions of dollars of unclaimed assets in this country, and every state has them. Eventually, they do go to the state. I mentioned already, again, a special envelope, a fireproof envelope for that will, that power of attorney, and other documents that are really important. Just so important to have that, and make sure they know where it is and communicate. So communicate with your loved ones where those documents are, at least the ones who are going to be in charge of taking care of them, if you don't give it to them directly. And very important, I think it's important to communicate what you plan to do to your loved ones. You don't necessarily have to tell them exactly, but like we're dividing up the estate. My goal is that everybody gets equal, or if you're giving more to one, explain to the other why you're doing that. Just really important. Surprises are not great, and the potential family conflicts are just horrific that can come out of this. Okay, a couple strategies. Again, these are just every year a good idea to review this type of stuff, and that's what I'm doing with most people these days when I meet with them. Okay, so I talked about a little bit, mentioned about probate, but the idea of avoiding or reducing probate is a very important idea. I didn't always believe that, but until I had to do some probate. I had to probate some wills and probate some estates. I've dealt with thousands of estates throughout my career. Most of the time, I'm representing nonprofits and charitable bequests. But in any case, I could see how terrible they are. So, how do you reduce the time, cost, and how we ever get agmas nefesh? I don't know if it's Yiddish or Hebrew, but the pain, the pain, suffering that could happen if with too much probate. Probate takes forever. So beneficiary designations, I mentioned, they're a good thing, because those assets that you designate out of your will, or maybe sorry, those things you designate in the accounts themselves. So your bank accounts, your brokerage accounts, your IRAs, all those assets go directly to your beneficiaries who are chosen, bypassing probate, which is they get the assets much quicker, and that's a good thing. And there's no cost. They just have to fill out forms. Joint ownership with a right of survivorship, that type of ownership, very important. For brokerage accounts, again, if there's if you're older person with you have a child, have the child as a joint owner, so they'll own it. So, for example, like my mother, I like to use her as an example. My sister's a joint account holder on a bunch of her accounts, so those accounts will not have to deal with probate. And my mom trusts my sister. I trust my sister, so I'm not worried. Had she not trusted my sister, maybe I'd say if we didn't trust her, either I'd say don't do that, or maybe have somebody else, myself or my brother, on there. So joint accounts again, just keep in mind if you put somebody as a joint account holder, they have the ownership of the account. They're basically owning the account also. They could withdraw the money. So if that's a problem for you, you have to talk to the bank. There are different ways to set up. It could be just set up that they only own the account upon your passing. That's called a pay on death type of account. But anyway, um, okay. So the joint accounts. Okay. Good thing to use it in the right way. Again, just be careful where you put on joint account. They literally have ownership of your accounts with you. Gifting. So another way, I just say my grandmothers, both of them came from Europe. Neither of them had a lot of assets. Never owned real estate. Actually, one grandmother, they owned a cottage up in Lake Peekskill, and they sold it for a couple $1,000s. It wasn't a big and nothing big there. So anything they had at a certain point when they were in their early 70s, they gifted whatever they had, whatever it was, to my parents, and that we'll get to talk about Medicaid. That was helpful. So there was really no probate. So my grandmothers, both my grandfathers passed away before I was born, but both my grandmothers, um, they basically had nothing left in their name. Everything was either a joint account with their child, or they gifted it away again to the child. So that was we'll talk about it in a second. Now, revocable living trusts. That's a type of very important document, very important trust. It's not for everybody, but if you've got real estate, maybe in multiple jurisdictions, you don't. I mentioned already. If you have real estate out of state, not a really good idea to put that real estate in a revocable living trust. Revocable living trust is basically uses your tax identification number, so it's basically a mirror of you. But again, it's I want to don't spend too much time on it because I want to get to Q&A. But a revocable living trust, it's like a super duper power of attorney will combined. So it guides things when you're disabled. Your replacement trustee steps in. You're the trustee to start. Replacement trustee steps in if something happens to you, and then so they can manage your assets if you're not able to. And then when you pass away, they distribute the assets according to what you wrote in the will. And they're great ways to reduce probate because they're not governed by they're a trust. It's outside the probate's hands. If there's a state tax involved, it could be still have a state tax, but at least you won't be mirrored down in probate. Possible Medicaid qualification. I talk about this all the time. I'll just use my mom example. Is she worried about using up any savings? If she ends up in a long-term facility, it could be $100,000 a year plus, maybe even more, $150,000 a year. How long will her retirement savings go? And she'd like to leave something for kids or her grandchildren. So essentially, my mom is now 85. Wow. So my mom is 85. Thank God she's been okay, pretty decent health. So because she didn't do what she did for her mom, she didn't give away all assets. She still has quite a bit, but she's been reducing it. But again, if she ends up in a nursing home, whatever hasn't been, it was been in her name for the last 5 years prior to going to a nursing home, it's 5 years, 5-year look back, would be counted against her. She would have to, so gifting, if you're going to do this, you want to do it earlier rather than later because it's a 5-year waiting period. So, because long-term care insurance, I'm not even going to talk about because it's so expensive. Even if you're in your 50s or 60s, very expensive. And you got to have that. You got to be cut off from the assets for 5 years. I have a client right now. I'm really just doing this as a volunteer to help a guy who was a teacher in Jewish schools for his career. He never really made a lot of money. He owns a house, and that's it. That's all he's got, and doesn't have retirement assets. So he wants to qualify for Medicaid. Well, he has to part with that house. He has to give it away. There's ways to do this, but he's got to separate himself from that house. And then after 5 years, then he can apply for Medicaid. He's currently around 70 years old. So when you get older, they get, it's either, once you get eligible for Medicare, they make it harder for you to get Medicaid. They don't want you to get both. want you to be one or the other. But anyway, he has got to be separated from those assets for 5 years. When my mom sold her house, we took the entire proceeds and put it in an irrevocable trust, which I'll talk about in a second, to get it out of her name. And it's been about 5 years. So whatever came out of that sale of my mom's house, that's protected because it's going to exceed that 5 years. It's in an irrevocable trust. So irrevocable trust is a little different than the revocable living trust. Now, irrevocable trust is mainly for Medicaid, possibly Medicaid qualification or some other complex things. But let's just talk about this. So irrevocable trust, again, the trust is, I actually set my mom's trust up to be, she actually paid taxes. I was able to do it so she could pay taxes on any of the income because we're holding the money and the growth for her. But it's out of her name and she can't take it back from us. It is irrevocable. My sister and I are the trustees, and it's a little more complicated than the revocable living trust, but again, it's going to protect assets for Medicaid. And again, gifting, we talked about could just give it all away as soon as you can. And that's one option for my other client, the teacher. He could just gift your house to your children today. Just donate it to them. Just you sell it for $1 to them. There's some not good tax consequences of doing that, so I'm not necessarily recommending that, and that's not what he plans to do. But it's an option. And actually, I recommend to them something called retained life estate. So again, I've done with a bunch of clients where they have a house or an apartment, they own it outright with no mortgage. They're able to change title of the property to a retained life estate. They retain the right to live it the rest of their life. They have control of it, but upon their passing, it's automatically can be owned by children, whoever you put as the remainder beneficiary. And if there's 5 years from the time you set that up, it's protected for Medicaid qualification. Again, this teacher client of mine, he's still nervous about it, but he should do it as soon as possible. But he's not listening to me yet on that one. Okay, so I don't want to forget legacy. I throw all these ideas out there, but essentially, this idea though that you have a legacy, something to think about, deeply. I know it's hard to in a 45-minute presentation. Now I'm up to 47 minutes, talking pretty quickly. I want to slow it down a little bit just for this 1 or 2 slides. Let's think about getting our planning in order. This is just advice I'm giving myself. Clean up stuff. Making sure our wishes are going to be filled. Make sure we've got the documents I talked about. We want to avoid chaos and battles in the future. We don't want to, because I can just tell you as a lawyer, and maybe you already have experienced this, state fights over assets, family assets. It's just the worst. They go on forever and ever, and then they're just families split up, and they temporarily never get back together over this, and it's really very sad. So, how do you want to be remembered? You don't want to be remembered for, we were fighting over dad's, estates for 20 years. We want to, that's not how you want to be remembered. Repair relationships, again, not so simple, but a good idea to think about relationships. I just saw that Simon and Garfunkel, Paul Simon and Art Garfunkel finally got together, and finally, Paul Simon told Art Garfunkel, why he was so mad at him for many years, and they cried, and they repaired the relationship. It's too bad they spent many years not, angry at each other, but they weren't related to each other, but they're take opportunities to create memories with loved ones, trips, places with family trips. So I didn't appreciate this stuff because it's actually, some of the stuff is very expensive. I just did a wedding, again, for my youngest daughter, just got married. So these are all big events. Savor them, enjoy them, take pictures too. But as we get older, we want these events become more and more important to us, and part of our legacy is how we're going to be remembered. And communicate your life message with loved ones again. And part of what I want to just talk about is that legacy planning includes personal issues and connect your friends and relatives and close family, but also the things that mean a lot to you. Charitable causes. This is, I always like to talk about, the aligning of values to be preserved for the future. That's really where, and you're talking about obviously personal legacy is one thing, but also your legacy with the world, how you want to impact the world, things that are just important to you. Does the organization represent things you want to see continued? Does the worker circle, which is has do their fight, is that your fight? Is that's something you want to see continued for the next generation? So think about a legacy gift through them. Could be anything. It could be a symbolic gift. It could be in your will. I'll talk about the next slide. Again, aligning your values to be preserved for the future. That's really where the last part of your legacy, once after family issues. And so here's some charitable ideas. Again, this is my main profession besides being a estate planning attorney. Again, include those charities that are important to you, the ones you've been involved with, the most ones that you feel are making the impact that you would like to see continue. It could be in your will. If you have a trust, you can include them in your trust, revocable or irrevocable, either way. It's similar to a bequest. That you could put a charity as a beneficiary of your IRA, of a life insurance plan, other accounts, policies. Again, you could be a partial beneficiary, you could be a full beneficiary. All different options are out there. And there is something, and we're running out of time, so I'm not going to have a lot of time on this, but there's something called life income gifts. We do this at the Worker Circle. Individuals who are age 60 plus can go ahead and if you're already thinking about leaving a bequest to Worker Circle and you want to learn about what's called a charitable gift annuity, you create an annuity based on your age. And there's a foundation that we work with that actually issues it because they've got a lot of money under management to manage these annuities. But essentially, you get an income tax deduction. You'll get a nice income stream, 6-7%. I just ran an illustration today. It's over 8%. It all depends on your age, or it's 1 or 2 lives. But again, nice idea. So if you have anything that comes out of this, particularly these last ideas, definitely check in with Shelly and the team at Worker Circle. They can always get in touch with me. But again, something to keep in mind. And unusual things, real estate, art, jewelry, and other valuables. I've dealt with individuals using these also for their legacy gifts. Okay, so we have 8 minutes. I can go a little further. I see. Let me undo this. Stop the share and answer the question. Okay. Question: advice for minimizing will-related disputes when some relatives are not named as beneficiaries. Well, I think that's a great question. I give an entire presentation on it, and I don't have time to give the entire presentation now. But let me give you my top pieces of advice. Well, number one, I mean, I hate to sound repetitious, but you've got to make sure you got a good will. You got to make sure the will is done well. If you expect a potential battle, you should tell an attorney, these are the people I'm naming my will, but these are the people I'm not naming. And if it's a child, you're going to have to state a reason. You should really state a reason why you're not naming that child. And in the will itself. Again, so the more potential for dispute, the more legal scrutiny you should have more of go to. Instead of just someone doing it as a favor, you should go to a law firm and let them do it for you. Because again, it may cost you a couple $1,000s, but you will save your family and relatives untold amounts of disputes. And could be using a living trust is also another way to limit the ability for a family to fight. Now, the only person who could challenge a will, it's very important to know this, you have only the next of kin. So obviously a child is next of kin, a spouse is next of kin. But if there's a spouse and or children, your parents or your siblings are not next of kin. So only the next of kin, the next in line, the person who would a person who would inherit from your will if you died without a will. And that is the only ones who can actually have standing in court to make a challenge. And so keep that in mind. So don't worry about distant relatives if you have closer relatives who you're leaving money to. But if you're bypassing anybody who is next in line, they can challenge it. And depending on the size of the estate, unfortunately, it's pretty hard to stop them from challenging the will. But again, you could turn to a more complex option, which is basically creating a living trust or an irrevocable trust. That creates, doesn't guarantee someone can't challenge it, but it definitely puts you in a much better position. Good records. Again, make sure the attorney who does your will, again, knows knows this, and that's a potential challenge to your estate. Are there any questions I missed? Because there was somebody raised their hand, and I just didn't know how to. I just didn't see the question. Yeah, there were no questions, and we're still in the chat. Hold on one second. Okay, well, I think we've reached pretty much the end here. I hope this was helpful, and I just want one last statement before you guys end the video. I really want to, you know, people tend to get very concerned, particularly when it comes post-election. Just sort of doomsday thoughts, and particularly and then what's going to happen with this area, particularly in states and trusts and taxes. And my experience has been is that it's never really gone too extreme one way or another. And so I think that you should not be concerned that there's going to be something negative coming down the pike in that regard. There could be other stuff that I cannot say anything about. But when it comes to this area, I've been following it for a long time. George Bush II, he did a pretty big bill, and we were making people were very upset about it. Some of the things he put in there. I wasn't too particularly pleased with some of the things that were in there, but end of the day, it was, like I said, neither here nor there. I don't know if it was good or bad. It was fine. We lived with it. It expired, and they upped it during Obama's administration, and but it tends to be we all have like a certain path. Things seem to just continue on in a sort of normal way. And that's the way I expect that. Anyway, somebody say thank you. Last messages as we're all about to pop off to another meeting. Thank you everybody for joining. And Shelley, you want to?
Sure. Thank you very much, Jonathan. That was terrific information. I've taken tons of notes for my personal follow-up. We have recorded the program, and we'll be sending you the slides and the recording. Please feel free to share these with your family and your friends who may be interested. I hope you enjoyed the program. Usually we offer these webinars twice a year, a mid and a year-end estate and retirement check-in. If you have a topic that you'd like us to cover in our webinar, please let us know. If you have any questions about our webinar or about the Worker Circle's current programs or plan giving options, please contact us at info@circle.org. If you'd like to contact Jonathan, please let us know and we'll be happy to connect you to Jonathan. Thank you, Jonathan and Danielle, and thank you all again for joining us at our end-of-year webinar. We look forward to seeing you at our program in 2025. Thank you.
Thank you, everybody.